More trademark troubles for Prince Harry and Meghan Markle. I'm going to spend the next 4 minutes talking about that. I'm Angela Langlotz, trademark and copyright attorney, and I go live here on weekdays to talk trademarks and copyrights. So, there seems to be no end of trademark troubles for Prince Harry and Meghan Markle. You'll recall that earlier this year, they were refused registration by the Queen, not really refused registration, but the Queen said, no, I don't want you to register your Sussex royal brand. So that put a kibosh on that because you can't go against the Queen, right? Your own mother-in-law or grandmother-in-law. So what they did was they filed another trademark application for, among other things, charitable goods and services related to their apparent desire to have a charitable foundation. Well, sadly, it looks like that trademark application is not going to go through either because they were refused registration by the U.S. Patent and Trademark Office for it being confusingly similar to another pre-existing application for a trademark. So how it works is that when you file, the trademark office goes in and they look at the trademark record. And if there is something that is confusingly similar, in other words, that might cause confusion between consumers, then your trademark will be refused registration and you will be issued what's called an office action. An office action can be, we need more information, but in this case, it is an outright refusal for being confusingly similar with an existing application. So let's go have a look. So this is their trademark application here. You can see that it was filed as a 1B status. You can see that right here. And 1B means that they have an intent to use the trademark in the future. It was filed March 3rd, 2020, and it is not unusual for this sort of application or any application to be reviewed 3 or 4 months later. That is the standard delay for trademark applications. Now, this was filed by Venable LLP, a high-priced Los Angeles firm. They have offices not only in LA, but in other cities as well. And I'm really surprised that they didn't catch these mistakes. Let's go look at the refusal. This was refused. You can see the attorney who filed it here, Marjorie Norman at Venable. And the summary of issues, this lays out the exact reasons for the refusal. So there is a prior filed application. Really surprised that Venable didn't do a thorough search in order to find this conflict. Classification and identification of goods and services. This is basic, folks. You should be able to fairly describe and accurately describe your goods. There is a whole manual that we use to do that. Multiple class application requirement. They didn't pay the fees, apparently, for all of the classes. That also surprises me. That's a basic mistake. And then the application was unsigned. What's up with this? This is a comedy of errors. None of these should have ever been an issue. Okay, so let's go and look at the goods and services that they were filed under. Oh, wait, but before we do that, let's see what the cited mark was. The cited mark is ARCHEWELL, and I don't know if that is really obvious here, but it has the same beginning part of the mark. And when I do a trademark search, I always make sure to search the beginning part of the mark to see if someone else is using something that starts with the same set of letters for similar goods, because that is a factor in determining whether or not something is going to be found confusingly similar. But let's go back and see the goods and services for which they're filing. Now, they have a whole bunch of listed goods and services here. This trademark application will not issue until use happens on all the listed goods and services. If you don't use the mark on all the listed goods and services, that is grounds for later cancellation of your trademark. So be very careful to make sure that you're not claiming a hugely broad list of goods and services that you're not actually using the mark on. That is a common amateur mistake. I call it a kitchen sink trademark. We just throw in everything in the kitchen sink and then we actually never use it on those goods. Well, that is grounds for cancellation. So let's go ahead and look at all of the goods and services. Now here they have downloadable articles. This is class 9, motion picture films, digital entertainment. This mark will not issue, if it issues at all, even if they can overcome the confusingly similar objection, and I don't think they can, but they're going to have to use the mark on all of these listed goods and services before it will issue. They also have fiction and nonfiction books, pens, pencils, notebooks, journals, clothing, charitable services, charitable fundraising services, and development and dissemination of educational and training materials, a whole list of those, and then websites on the field of nutrition, general health, and then organizing and conducting support groups for persons in need. So this is a very ambitious trademark application, and you only have 3 years to prove use after you file one of these 1B applications. So I would be very surprised if all of these goods and services were found in the original, in the trademark registration, assuming that they're able to overcome the rejection. Anyway, sorry, Prince Harry, Meghan Markle, it looks like it's back to the drawing board to find a mark that doesn't present a conflict with an existing registration. I'm Angela Langlotz, and I go live here to talk trademarks and copyrights. Message me on Facebook.com/TrademarkDoctor with any trademark questions. Find me online at TrademarkDoctor.net, or you can go see my huge library of trademark and copyright law videos on YouTube. Just search Trademark Doctor.